My name is Stephanie Cumley, and I am an HR advisor with TPC Vision. Our Vision team provides HR managed services to support the business needs of clients. We have put together the following slides to highlight the main components of the Families First Coronavirus Response Act, along with the Q&A section at the end to answer some of your most pressing questions so you can make informed decisions. We know you're receiving information from many different sources, so we want to thank you for taking the time to listen to our webinar today. In this unprecedented time, many businesses are struggling to navigate through this uncharted territory. We hope to provide you with information today that will help you move through this evolving situation and come out stronger in the end. We are here to support you as we all work through this together. I know many of you have been asking questions about the Families First Coronavirus Response Act, which was signed into law the end of last week. We are going to take a look at the major provisions of the law and also look at employer best practices through the Q&A section at the end of the presentation. Before we jump in, I want to mention that we are not attorneys and the information provided in the presentation should not be construed as legal advice. We encourage you to consult an attorney if you are seeking legal advice. The purpose of the legislation is to extend additional assistance and protections to individuals and businesses affected by the COVID-19 crisis. Today we are going to cover the Emergency Family and Medical Leave Expansion Act, the Emergency Paid Sick Leave Act, refundable tax credits to pay for leave, Emergency Unemployment Insurance Stabilization and Access Act, and then we're going to cover some Q&A at the end of the presentation. So who is considered a covered employer under the Emergency Leave Acts? They are private employers with fewer than 500 employees, and that is for each working day during each of the 20 or more calendar work weeks in the current or preceding calendar year that are engaged in commerce or in any industry or activity affecting commerce. All public agencies that employ one or more employees or other entities that are not a private entity. The next thing we're going to look at are any exemptions that exist. Well, the Secretary of Labor has the regulatory authority to exempt employers with fewer than 50 employees if the provisions would jeopardize the viability of the business as a going concern. The Secretary of Labor can also exclude certain healthcare providers and emergency responders from the definition of eligible employees. So now we're going to look at some definitions. So what is considered the leave purpose under the Emergency Family and Medical Leave Expansion Act? Well, that is a qualifying need related to a public health emergency. So what is a qualifying need under this act? Is defined as to mean the employee is unable to work or telework due to a need for leave to care for the son or daughter under 18 years of age of such employee if the school, meaning a primary or secondary school only, or place of care has been closed, or the child care provider of such son or daughter is unavailable due to a public health emergency. So what is considered a public health emergency? It's defined to mean an emergency with respect to the COVID-19 declared by a federal, state, or local authority. The provisions of this act are effective on April 2nd, 2020, and will expire on December 31st of 2020. So let's talk about which employees are covered under the Emergency Family and Medical Leave Expansion Act. These are employees who have been employed for at least 30 calendar days. Now, this is different than the regular 12-month period under current FMLA guidelines. It's also for employees where telework is not available for them. They're entitled to up to 12 weeks of job-protected leave. The first 10 days of this time is considered unpaid leave, or the employee can choose to use accrued vacation, personal, or sick leave, or leave time under the Emergency Paid Sick Leave Act, which we'll talk about in just a moment. After the initial 10 days, the employer is required to provide paid leave based on an amount that is not less than 2/3 of an employee's regular rate of pay, and the number of hours the employee would otherwise be normally scheduled to work. There is a cap on this amount. The employee is entitled to no more than $200 per day or $10,000 in the aggregate per employee. Employers with 25 or more employees would be required to reinstate employees to the same or equivalent position after their FMLA leave period ends. Employers with fewer than 25 employees do not have to reinstate an employee to the same or equivalent position if the requirements would jeopardize the viability of the business as a going concern. Refusing to restore requires the following. The position does not exist when the employee returns because of the public health emergency. The employer tries to find a position to return the employee to at the end of the leave, and the employer makes a reasonable effort for 1 year after leave to return the employee to work if a position becomes available. So now let's talk about the Emergency Paid Sick Leave Act. Under this act, employers must provide all full-time employees with 80 hours of emergency paid sick leave related to the coronavirus, with special rules for part-time employees, to the extent that the employee is unable to work. There are 6 criteria an employee could meet in order to be eligible for this leave. Number 1, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Number 2, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Number 3, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Number 4, the employee is caring for an individual who is subject to a federal, state, or local quarantine or isolation order related to COVID-19, or an individual who has been advised by a healthcare provider to self-quarantine due to COVID-19 related concerns and seeking a medical diagnosis. Number 5, the employee is caring for a son or daughter of such employee if the school or place of care of the son or daughter has been closed, or the child care provider of such son or daughter is unavailable due to COVID-19 precautions. Number 6, the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. Under circumstances 1, 2, and 3, the employee will be entitled to 100% of their pay, and under circumstances 4, 5, and 6, they will receive 2/3 of their pay. Under the Emergency Paid Sick Leave Act, full-time employees are entitled to 80 hours of paid leave. Part-time employees are entitled to a number of hours equal to the number of hours that such employee works on average over a 2-week period. This is available to all employees regardless of how long they've been employed with the company. It ends with the employee's next scheduled work shift following the end of the qualifying need. Paid sick time under this section shall not carry over from 1 year to the next. Sick pay is calculated based on the employee's regular rate of pay, or if higher, the applicable minimum wage rate. For qualifying reasons 1, 2, and 3 in the previous slide, employees' pay will be based on 100% of their regular rate of pay. The maximum amount of required sick pay per employee is $511 per day and $5,110 in the aggregate. For qualifying reasons 4, 5, and 6 in the previous slide, the employee pay is based on 2/3 of the regular rate of pay. The maximum amount of required sick pay per employee is $200 per day under these qualifying reasons and $2,000 in the aggregate. Also under this act, employers will be required to post a notice. This notice should be available soon. This act also prohibits employers from discharging, disciplining, or discriminating against employees. It prohibits employers from requiring employees to look or find replacement employees to cover the hours during which the employee is using the paid sick time. These violations are punishable under the Fair Labor Standards Act. Employers cannot require employees to use other paid leave provided by the employer before the employee uses the emergency paid sick leave. These provisions are effective on April 2, 2020 and will expire on December 31, 2020. Although the normal qualifying reasons are not applicable to employers with fewer than 50 employees within a 75-mile radius, the provisions of the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act will apply to employers who have between 0 to 49 employees. As you can see at the bottom of this slide, employees taking leave for qualifying reason number 5 which is to care for the employee's child whose school or place of care is closed or the child care provider is unable to provide child care due to COVID-19. Employees may use the emergency paid sick leave during the first 10 days and then also possibly be eligible for the Paid Emergency Family and Medical Leave Expansion Act. Employers with 50 to 499 employees will still need to follow their regular Family and Medical Leave Act guidelines. They will also be required to follow the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. Employers with 500 plus employees will still need to follow the regular Family and Medical Leave Act guidelines, but are not subject to the Emergency Paid Sick Leave Act nor the Emergency Family and Medical Leave Expansion Act. However, we do anticipate there will be further guidelines issued for employers of this size. The paid leave for these employees will be refundable to employers through tax credits. These will be applied against the employer portion of Social Security taxes for each quarter equal to the qualifying paid leave wages paid by the employer. The amount of the tax credits vary based on the type of leave. The tax credit would apply to wages the employer pays between April 2, 2020 and December 31, 2020. Employers are provided a refundable tax credit equal to 100% of both the qualified family leave wages that the employer is required to pay and the Medicare tax paid on said wages. The credit is claimed on the quarterly Form 941. Employers are not subject to the Social Security tax on employee wages. That tax is normally 6.2% of wages up to the annual Social Security taxable wage base of $137,700 for 2020. However, employers are still subject to the Medicare tax on employer wages. The amount of the qualified family leave wages that would be taken into account for purposes of the credit per employee is $200 for any day for which the employer pays the employee qualified family leave wages, up to a maximum amount for all calendar quarters of $10,000 per employee. Under the emergency paid sick leave, employers are provided a refundable tax credit equal to 100% of qualified sick leave wages that the employer is required to pay for a given quarter. The amount of qualified sick leave wages for the purposes of the credit would vary depending on the reason for the leave. For employees who must self-isolate, obtain a coronavirus diagnosis, or comply with a self-isolation recommendation from a public official or healthcare provider, the amount of the qualified sick leave wages taken into account is capped at $511 per day. The law also allows for an increase in the amount of the tax credit equal to the amount of the employer's qualified health plan expenses as are properly allocable to the qualified family or sick leave wages for which such credit is allowed. So how do employers get reimbursed? For TPC clients, TPC can establish earning codes that will be active effective April 2nd that will be used for tracking qualified wages for both family leave and sick leave. TPC clients should use these codes when entering employee pay that is covered under the FFCRA. Please talk to your customer service team member to get those set up for you. The payroll tax credit is taken on a quarterly 941 for 100% of the qualified wages and is refundable. The credit must be recorded as income on your business return to offset the additional wages that are being recorded. Employers can add any increased health plan due to the emergency leave wages. Self-employed individuals get similar credits, but they are calculated differently. Another component of this legislation is the Emergency Unemployment Insurance Stabilization and Access Act. $1 billion in grants are being issued to states for emergency unemployment insurance. $500 million will be transferred to the states within 60 days after enactment of the law. The states must require employers to notify employees of the availability of unemployment benefits. States must also ensure that applications for unemployment compensation and assistance with the application process are accessible in at least two of the following ways: in person, by phone, or online. Another $500 million will be reserved for states in which the number of employment claims has increased by at least 10% over the same quarter in the prior calendar year. These states must make it easier for individuals to get unemployment benefits by waiving work search requirements and waiting periods. Additional requirements may unfold in the coming days and weeks. This brings us to our question and answer segment of the presentation. The first question is, what are the different components of the Families First Coronavirus Response Act? Well, we have covered Division C, D, E, and G in our presentation today. However, there are other components of the Act, including the Second Coronavirus Preparedness and Response Supplemental Appropriations Act, nutrition waivers, health provisions, and budgetary effects. Question 2. Under the Emergency Family and Medical Leave Expansion Act, how do I determine the number of hours an employee should be paid? For employees working a regular schedule, you would use the number of hours an employee would otherwise be normally scheduled to work. For employees working a variable schedule who have been employed for 6 months or more, you'll use the average number of hours that the employee was scheduled per day over the 6-month period, ending on the date in which the employee takes such leave, including hours for which the employee took leave of any type. For employees employed less than 6 months, you'll use the average number of hours per day that the employee would have been scheduled to work. Question number 3. Under the Emergency Paid Sick Leave Act, how do I determine the number of hours of paid sick time to which my employees are entitled? For full-time employees, you will use 80 hours. For part-time employees, you'll use the average number of hours an employee works over a 2-week period. For part-time employees working a variable schedule, and for those employed 6 months or more, you'll use the average number of hours that the employee was scheduled per day over the 6-month period, ending on the date in which the employee takes leave, including those hours for which the employee took leave of any type. For employees working less than 6 months, you'll use the average number of hours per day that the employee would normally be scheduled to work. Question number 4. If I have already provided at least 2 weeks of sick time, or PTO, do I still have to comply with the Emergency Paid Sick Leave Act? Yes, the bill is very clear that these provisions are in addition to any existing benefits received through the employer's existing paid time off benefits. Can an employer require an employee to use their PTO, vacation sick time, before being eligible for emergency paid sick leave? No, the provisions state that an employer may not require an employee to use other paid leave provided by the employer to the employee before the employee uses the paid sick time. Question number 6. Can I take away or adjust my company paid time off benefits or policy for employees that take emergency leave? No, you cannot take away paid time off benefits for employees that utilize the emergency leaves under the FFCRA. If you plan to redo your company's paid time off policies, you must be consistent in implementing the new policy to all employees, regardless of if they took the emergency leaves or not. You will want to ensure that you evaluate the balances and parameters of your paid time off benefits before making changes during this time of uncertainty. Question number 7. May an employer send home an employee involuntarily who has or is exhibiting symptoms of COVID-19? Yes, you can. In response to the current COVID-19 outbreak, the Equal Employment Opportunity Commission states that advising workers with symptoms to go home is not a disability-related action if the illness is akin to a seasonal influenza and is permitted under the Americans with Disabilities Act if the illness is serious enough to pose a direct threat to the employee or coworkers. Further, the Centers for Disease Control advises that employees with symptoms of acute respiratory illness and a fever, which is greater than 100.4 degrees Fahrenheit or 37.8 degrees Celsius, using an oral thermometer, should stay home. Of course, employers should apply this type of policy uniformly and in a manner that does not discriminate based on any protected characteristic, such as national origin, gender, race, etc. Question number 8. In what situations can I send an employee home involuntarily? Number 1, the employee has a confirmed positive test for COVID-19. Number 2, the employee is presumptive or suspected positive for COVID-19. Number 3, the employee is symptomatic of COVID-19 but not yet tested. Number 4, the employee is asymptomatic but has been in close contact with someone who has tested positive for COVID-19. Number 5, an employee is asymptomatic but has been in close contact with someone who is symptomatic, or presumptive suspected positive for COVID-19. Number 6, an employee is asymptomatic but recently traveled to a high-risk area. Number 7, an employee is asymptomatic of COVID-19 but has flu-like symptoms. Question number 9, does an employee need to provide a doctor's note to substantiate that they have tested positive for COVID-19? While you may request it, according to CDC guidelines, employees do not need to provide a healthcare provider's note if they are sick with acute respiratory illness to validate their illness, as healthcare provider offices and medical facilities may be extremely busy and not able to provide such documentation in a timely manner. Question 10. If an employee is confirmed positive for COVID-19, can I require a return to work release? Yes, you can require a return to work release. The employee should be fully symptom-free for a period recommended by a medical provider. Please keep in mind, though, as a practical matter, however, doctors and other healthcare professionals may be too busy during and immediately after a pandemic outbreak to provide fitness for duty documentation. Therefore, new approaches may be necessary, such as reliance on local clinics to provide a form, a stamp, or an email to certify that an individual is fully symptom-free for the doctor-recommended period. Question 11. What do I do if an employee is presumptive or suspected positive or symptomatic but not yet tested? Well, you can require that they be off work for a period of up to 14 days to await the test results. If they test positive, you can require a return to work release. If they test negative, you can allow them to return to work, but you may want to require a return to work release to ensure that they are not contagious per any other viruses. If they are unable to get tested, you can require them to be off work for 14 days. Again, as a practical matter, we may not be able to get this documentation as healthcare providers may be busy. Question 12. What do I do if an employee is asymptomatic but was in close contact with an individual who tested positive for COVID-19, is asymptomatic but has flu-like symptoms, or has recently traveled to a high-risk area? Well, you can require that they be off work for a period of up to 14 days. If they test positive or develop symptoms during this time period, you can require that they remain off work until fully symptom-free for a period recommended by the medical provider and require a return to work release. If they are unable to be tested, you can require them to be off work for 14 days. You may want to consider paying them for this time off if possible. Question 13. Can I place a personal travel ban on employees for the well-being of other employees or customers? It is not advised to implement a personal travel ban to employees, but you can prevent employees from returning to work for 14 days if they have traveled to a high-risk area. Question 14. What if one of my employees refuses to work because of a generalized fear or they claim that the workplace is unsafe due to the virus? You can require them to work as long as there is no legitimate threat and they do not require an accommodation. Under OSHA guidelines, employees are protected from retaliation in certain circumstances when they refuse to perform work as directed. Specifically, an employee may refuse an assignment that involves a risk of death or serious physical harm if certain conditions apply. While each situation is different and a generalized fear of contracting COVID-19 is not likely to justify a work refusal in most cases, employers may want to conduct a thorough review of the facts before any disciplinary action is taken against an employee who refuses to perform his or her job for fear of exposure to COVID-19. Even if the employee's refusal is deemed justified, the OSHA Act does not require that the employee be paid for any time he or she is not at work due to his or her refusal. Question 15. Can we take employees' temperatures? This is generally considered a medical test and is prohibited. However, if COVID-19 becomes widespread in the community, as determined by state or local health authorities or the CDC, then the EEOC does allow employers to take the temperature of employees as long as it is done in a uniform manner and does not violate union contracts, HIPAA rules, etc. COVID-19 is now officially a direct threat, and employers may take the temperatures of its employees as it relates to determining if an employee may have symptoms of COVID-19. Keep in mind that employees may be infected with COVID-19 without exhibiting recognized symptoms such as a fever, so temperature checks may not be the most effective for protecting your workforce. We encourage you to have employees work from home when possible, and for those employees who cannot work from home, encourage them to self-report symptoms. Question 16. May I screen applicants for symptoms of COVID-19, and can I take their temperature? Yes, an employer may screen job applicants for symptoms of COVID-19 after making a conditional job offer, as long as it does so for all entering employees in the same type of job. This ADA rule, allowing post-officer, medical inquiries, and exam applies to all applicants, whether or not the applicant has a disability. Question 17. What things should I consider when implementing changes? Well, under the Occupational Safety and Health Act, OSHA, there's no specific safety standard or regulation for contagious illnesses or diseases. However, there is the General Duty Clause, which states that workplace should be free from recognized hazards that are causing or likely to cause death or serious physical harm. OSHA recommends following federal, state, and local health authorities. Also, they recommend to follow their recommendations based on worker risk of occupational exposure, which includes exposure risk levels for positions that may be very high, medium, and lower exposure. You must record instances of workers contracting COVID-19 if the worker contracts the virus while on the job and performing job duties. This illness is not recordable if a worker was exposed to the virus while off the clock. They also recommend for employees working from home, as you would for any employee working from home at any time, to ensure that the workplace is safe and free of recognized hazards. So let's take a look at workers' compensation. Each state has specific guidelines that you will need to follow. Under workers' compensation, it must be an occupational illness or disease and normally arise out of and in the course and scope of employment to be compensable. This means that the employee must contract it as a result of performing their job duties and wouldn't normally contract it outside of work. A contagious or communicable disease which an employee contracts or to which exposed at work is not typically compensable. However, if it is contracted as a result of performing the necessary part of job duties, such as a healthcare worker caring for a patient who is tested positive, it may be compensable. Next, let's take a look at the Americans with Disabilities Act. Under the ADA, employers should take a look at whether it's job-related and consistent with business necessity. Employers will want to consider if an employee poses a direct threat, which is a significant risk of substantial harm to self or others while working. Employers should be cautious when communicating with employees to ensure that their inquiries are directly related to COVID-19, such as traveling to a high-risk area, symptoms of COVID-19 or other illnesses with similar symptoms such as the flu, or questions revolving around potential exposure to COVID-19 and related tests or results. Be very careful not to make inquiries that would elicit information about current medical conditions. Under the Family Medical Leave Act, pandemic flu likely constitutes a serious health condition if it meets the regular criteria for a serious health condition. For example, an overnight stay in a hospital. Keep in mind, medical certifications and return to work releases may be difficult to obtain if healthcare workers are overwhelmed. Employers should also take into consideration the Age Discrimination in Employment Act. Employers should not make inquiries about symptoms in a discriminatory manner. For instance, don't ask questions to older workers, but not ask the same questions to younger workers. We also don't want to isolate older workers, but not younger ones, to force social distancing. Under the Fair Labor Standards Act, exempt employees must be paid for a full day if the employee works any part of that day. Employers should also pay the exempt employee for a full work week if the employee works any part of the week. There are limited exceptions, such as full day deductions for FMLA leaves of absence, personal reasons, etc. For non-exempt employees, employers are not required to pay for any time not worked, but may owe reporting time pay if applicable. Employers can require non-exempt employees to use PTO, vacation, and sick days until exhausted, as coordinated with the emergency leave requirements per the Families First Coronavirus Response Act. Question 18. Is an employer's knowledge that an employee has COVID-19 subject to the HIPAA's privacy restrictions? Well, not usually, unless the employer acquired the information in its role as the administrator of the health insurance plan. Because most employers will learn of a COVID-19 diagnosis from the employee or his or her family, the Health Insurance Portability and Accountability Act, or HIPAA, usually will not be implicated. However, we do recommend that you keep it confidential. Let employees know that there's been an exposure and notify affected employees to get tested, but don't mention who has it. Question 19. What things should I be considering? Many employees are looking at different options, including employees working from home or telework, looking at changing hours of operation. They're considering salary and wage reductions. However, keep in mind this may require an advance notice per state law, and the employer must retain exempt employees' salaries above the Fair Labor Standards Act salary threshold if applicable, and that employers must not take an employee below applicable minimum wage. Several employers are considering furloughs, layoffs, whether that be temporary or permanent, reductions in force, and unfortunately, the possibility of ceasing operations or permanently closing their business. Other considerations employers should be looking at when considering these previous options is the impact of the health insurance coverage for the employees and any availability of COBRA continuation coverage. They'll also want to coordinate their PTO, vacation, sick, personal time off policies and consider adjusting policies to provide additional time off, allowing employees to borrow against future accruals, allowing employees to borrow against future plan years as well. Keep in mind that an unemployment benefits may be available for any employee who is terminated, laid off, or furloughed. Question 21. What other resources do I have to help my business? The Small Business Administration, or SBA, will work directly with state governors to provide targeted low-interest loans to small businesses and nonprofits that have been severely impacted by the coronavirus. The SBA's Economic Injury Disaster Loan Program provides small businesses with working capital loans of up to $2 million that can provide vital economic support to small businesses to help overcome the temporary loss of revenue they are experiencing. You can find more information on the SBA's Economic Injury Disaster Loans at sba.gov/disaster. This concludes our presentation for today. We realize that you may have additional questions, and we encourage you to email frontdesk@thepayrollco.com if you have any further questions. Please watch for any future webinars where we try to answer the questions that you are submitting. Thank you for joining us today. We look forward to continuing to support you and your business.